Okay, everybody, welcome back. I hope you had a good breather and a good break. Um, for our final panel, the topic is on Métis as treaty parties. And we have Alexandre Michaud, who is going to chair the panel for us for this last panel this afternoon. Alexandre Michaud is really pretty much responsible for organizing this conference. He is my research assistant for the Métis Treaties project, and I know he'd rather be reading research than organizing and sending out emails and trying to arrange everybody's flights and agendas and stuff. And I really appreciate Alexandra helping out so much, even though it's an extra duty. So I just wanted to acknowledge that. And welcome, Alexandra. Darren's also on the panel. He'll be down. He's always late, so not to worry.
So hello, everybody. Thank you for being here for this session. Maybe I'd like to throw in some kind of a funny joke, a language thing. You clearly know that my first language is not English. Obviously, I've got a strong French accent when I speak English. And sometimes I struggle with words like indigenous or indigeneity. I feel like I have to dislocate my jaw somehow to say some of the words. But there's another word that, for me, was not a problem. I thought I was saying it properly. And I live with English-speaking people on my street, like good friends. But they always giggled when I was saying a certain word, and I want to use you as a test case to see if actually, there's something there. So whenever I use the word balls, like soccer balls or basketballs, they always giggle. And it took me a full year to understand why they were always finding this funny when I was using the word balls. For me, balls is balls. It's a ball, right? And I was just wondering about your reaction if I would ask the question like, what is your preferred Métis balls of the year that you attended to this year? And just to see like what people would think now that I know which way English sometimes use the word balls in a way that for me was completely unknown. So anyway, so that's my bit about language. Like funny parts, sometimes you say something and you don't know how it is received and why it is received in a certain way. So I am here to introduce our speakers. I'm really honored to introduce Dr. Adam Gaudry, who is Métis and assistant professor in the Department of Indigenous Studies at the University of Saskatchewan. Adam's research explores 19th century Métis political thought, the formation of a Métis treaty relationship with Canada in 1870, and the subsequent non-implementation of that agreement. So today, Dr. Gaudry will talk about the 19th century plain diplomacy. Please welcome Dr. Gaudry. Thank you.
Hello, everyone. I feel very fortunate to follow a number of really interesting discussions and several presentations that talk about Métis First Nations relations, because I think this is something really important. And in our quest to kind of really pin down Métis-Canada relations, I think at times we often kind of miss some of the complexity that existed well before that relationship. And what I actually argue is that the relationship that Métis formed with other Indigenous people was the format in which Métis approached their relationship with Canada when Canada arrived in 1869. So as a starting point then for understanding this relationship, I actually look to relationships with other Indigenous people. And while my colleague Rob Innes, I think, gave us a very detailed analysis, and his book is excellent, by the way. I know he didn't plug it, but I'm going to. Elder Brother in the Law of the People really explains this in an accessible and really convincing way that with certain peoples, the Cree, the Assiniboine, and the Saulteaux, Métis had, I think, very good prior relations, and were not only biological relatives, but were diplomatic relatives as well. And I'm going to get into a little bit about what I mean by that. But the idea that they were already family. But of course, Métis had relationships with other people who they weren't family, and that's what I want to focus on today, particularly the Métis and the Dakota, or at least part of the Dakota. So in 19th century prairie diplomacy, there was a stark distinction between communities who considered themselves relatives, friends, and strangers. Relatives could be counted on to give gifts, to share, to live side by side, and to be generally predictable in their actions. Strangers were unknown quantities and were almost always treated with caution. Friends, they laid somewhere in between, and they were predictable, often trading partners, but they weren't necessarily treated like family. They didn't necessarily give or receive gifts. There was a distinction there. Métis diplomacy then relied on establishing diplomatic protocols with their kin, with whom they shared a common diplomatic language, and it also involved protecting themselves from the probable danger of strangers. Determining whether outsiders were a total stranger, a friend, or capable of becoming a good relative was important in making these distinctions. Such considerations then structured not only Métis First Nation relationships, but Métis company relations, Métis in the North, and the Hudson's Bay Company, and Métis Canada relations as well. And given time constraints, and that many scholars, like Rob, have already examined Métis, Cree, Saulteaux, and Assiniboine relations, I want to focus on one event involving a treaty with a traditional enemy of the Métis. Stemming from a Métis-Dakota conflict in the winter of 1844-1845, Métis and Dakota, at least some Dakota, formed an alliance through a shared treaty culture that ensured the safety of their peoples on shared hunting territories. In Plains diplomacy, a common language utilized metaphors of kinship and family. This was used for both biological and non-biological kin. Brenda McDougall's work suggests that family responsibilities, using the Cree term Wokotowin, establish obligations across the boundaries of language, culture, and even nation. Wokotowin determined the qualities individuals were expected to personify as a good family member, values that were critical to family relationships. And as a common diplomatic language, Wokotowin contextualized how relationships were intended to work between these relatives by defining and classifying relationships. In the words of McDougall, by prescribing patterns of behavior between relatives and non-relatives. Wokotowin obligations were determined as much by diplomatic custom as by biology. Métis families were not confined to Métis relatives, but included by marriage, treaty, and biology, family members from other peoples as well. Throughout the prairies, as Rob Innes has noted, many hunting groups, bands, or family units in the 19th century were multinational, with families from many peoples living together in close-knit communities. These groups did not necessarily hybridize, but rather they maintained their multiple cultures, multiple alliances, and continued to speak their own language within these polyglot communities. This led to the establishment of regional bands, where membership, as Liam Haggerty notes, was flexible and often overlapped, allowing families to mobilize a variety of kinship ties according to the prevailing environmental and social conditions. So taking on a new family member often meant granting access to hunting territory to this new relation. In the 19th century Northwest, Indigenous geography functioned very differently from the bounded and discrete territories often attributed to the Prairie West today. Diplomacy and ideas like Wokotowin governed territoriality. Access to territory was determined then by a kind of constellation of lived relationships, where one's so-called national identity did not create an exclusive claim to occupy a particular physical space. Territory on the prairies then was not the exclusive dominion of a single individual or nation. It was rather a shared resource where use rights were claimed, negotiated, and exercised as part of the lived relationships that people forged with one another in the process of creating a landscape and social identity. Wokotowin informed where one lived and could live, where one hunted and trapped, and who one lived with. As strangers were made into family members, territory became an increasingly overlapped geography governed by diplomacy as kinship. Some treaties were formalized people-to-people agreements, but the vast majority of them were actually everyday ceremonies, like pipe ceremonies, gift exchanges, and weddings. Like family life, prairie diplomatic culture was premised on structuring relationships between families, bands, and peoples as obligation to kin. In this way, diplomacy in the 19th century Northwest relied upon family-level practices projected onto larger diplomatic processes involving more complex entities. Family was an accessible concept that everyone could understand. Its symbolism was mutually intelligible and resonated well with people from different cultures. Larger-scale diplomacy evoked family relationships in its imagery, reproducing the kind of relationship people were most familiar with. Knowing this, I want to now turn to how these relationships functioned on the ground, even among strangers, enemies, and the otherwise unrelated. According to Alexander Ross's Red River Settlement, in the autumn of 1844, the Siskiyou Dakota sent an emissary to the Métis chief, Cuthbert Grant, at Whitehorse Plains. The messenger carried a letter lamenting the death of several young men during a series of deadly skirmishes between Siskiyou warriors and Métis soldiers seeking redress for the Dakota's dead. The incident began when a Dakota war party ambushed a buffalo hunter, Louis Vallee, while he was processing a buffalo with his young son. Vallee had just enough time to direct his son to flee back to the Métis camp before he was killed in a shower of arrows. But Métis revenge was swift. As soon as Vallee's son made it back to the Métis camp, Ross notes, the alarm was given, and 10 half-breeds, mounting their horses, overtook the murderers in less than an hour. While some Dakota fled, the others, 4 Siskiyou and 4 Yankton Dakotas, were overtaken and shot down like beasts of prey. Resulting from these deaths, the Siskiyou sought either revenge or restitution from the Métis. So they met in council to discuss whether it would be war or peace with the Métis, and they resolved to send an emissary to the Métis at Whitehorse Plains. In their message, the Siskiyou stressed their love for peace, but also their warriors' desire to revenge their dead. They told the Métis that the pipe of peace had not been in our council for the last 6 days. In other words, they were readying themselves for war. They lamented how their young men had been killed. They said they were good warriors, their friends cry, our hearts are no longer glad. And the Siskiyou demanded 4 cartloads of gifts to compensate their community for the dead warriors. And this alone would allow the Métis and the Dakota to avoid war. To drive their point home, the Siskiyou declared that the Métis were, quote, now strangers, meaning that the Métis were no longer kith or kin and thus unable to call upon any prior obligations among the Siskiyou to protect them from violence. Since sharing and trade were practices undertaken only among those who shared common social obligation as friends or relations, Métis and Siskiyou political and economic relations were also severed by this declaration. But this declaration was not a declaration of war. Rather, it was an invitation to become friends again. The Dakota ultimately told the Métis this, friends, tell us, are we to be friends or enemies? Is it to be peace or war? In other words, they were readying themselves for war. They lamented how their young men had been killed. They said they were good warriors, their friends cry, our hearts are no longer glad. And the Siskiyou demanded 4 cartloads of gifts to compensate their community for the dead warriors. And this alone would allow the Métis and the Dakota to avoid war. To drive their point home, the Siskiyou declared that the Métis were, quote, now strangers, meaning that the Métis were no longer kith or kin and thus unable to call upon any prior obligations among the Siskiyou to protect them from violence. Since sharing and trade were practices undertaken only among those who shared common social obligation as friends or relations, Métis and Siskiyou political and economic relations were also severed by this declaration. But this declaration was not a declaration of war. Rather, it was an invitation to become friends again. The Dakota ultimately told the Métis this, friends, tell us, are we to be friends or enemies? Is it to be peace or war? Till now, our hands have always been white, and our hearts good. Friends, we are not frightened. We are yet many and strong. Our bows are good, but we love peace. We are fond of our families. Friends, our hearts were not glad when we left you last. Our shot pouches were light, our pipes cold, but yet we love peace. Let your answer make our wives happy and our children smile. The Métis responded diplomatically with empathy, claiming to share in the sense of loss over the dead. The Métis said, too, that they were as sad as yourselves, and feeling that while recent events had created a momentary disruption to the pipe of peace, the Métis hoped that it would not wholly extinguish it. The Métis also referenced a half-century or more where the Dakota and Métis had smoked the pipe of peace together. Yet the Métis leadership insisted that the Métis were the wrong party, acting in self-defense, and that the Dakota warriors were struck first. The Métis expressed their regrets for the 4 dead Sissitus and the 4 dead Yankton, but the Métis reminded the Dakota that they had actually forgot to express their regret that Métis were killed also. The one fact is that, well known to you, the Dakota, as the other, that they were killed first, the Métis. It is in this manner that the Métis categorically refused to repay the Sissitu for their 4 dead warriors. They responded, "You demand from us 4 loaded carts for the Sissitus. We never refuse paying a debt, but never consent to paying an unjust one. You know your people were the first aggressors." The Métis then answered the Sissitu question of whether there would be peace or war by turning the question back to them. You put the question, shall we be friends or enemies, or shall there be peace or war? We leave yourselves to answer that question. They who would have friends must show themselves friendly. We have not violated no faith. We have not broken no peace. We will break none. We will not go to find you to do you harm. The Métis then reassured the Sissitu that we are for peace and that peace is our motto, but that they were also ready for war, stating that we will defend ourselves should you be as numerous as the stars and as powerful as the sun. The Sissitu received the Métis reply in their council, and they discussed it extensively for 3 days while at White Bear's Lodge, with strong proponents representing both positions of peace and war. Ultimately, however, their council received the message as one of peace, and they sent the Métis a response calling on the creation of common bonds between the affected families to foster peace between the 2 people. The Sissitu reply evoked the shared language of prairie diplomacy. In essence, the Sissitu called for the creation of kinship bonds between the family of their dead and the families of the Métis warriors who had killed them. Among these were adoptions and gift-giving from the dead Sissitu warriors' possessions. One Dakota, recorded as Tawa Chankan, told the Métis, "Friends, you have killed my son. He was brave. Sanbi gi a tutan. He who pointed the gun at him, I wish him to be my son. He had a feathered wand in his hand. I send it to my adopted son." Well, Kantiki wished to adopt a father from the Métis warriors who had killed his own, stating, "Friends, you killed my father last summer. I wish him who made me fatherless should be my father. He was a chief, a Sissitu warrior, had a gun and a bow, had been scalped young. His feathers reached the ground. Whoever will wear these proud feathers, I will give him a horse. I will be proud of him." These statements, along with 4 additional offers to adopt Métis soldiers into their families, contain the gift-giving rituals that established obligation and kinship. They were, in effect, treaties. By offering the Métis hunters the possessions and the social capital of the dead Sissitu warriors, they were proposing to make kin out of strangers, or alternatively, kin out of friends, an action that would situate diplomacy in the language of family obligations rather than the more unpredictable diplomacy of non-relatives. By integrating these Métis outsiders into the Sissitu family network, and then by also including Sissitu families in the Métis kinship system, increased levels of attachment would, at least in theory, help limit the violence which regularly erupted between them. Family had obligations. They were to share their resources, to look after one another in times of insecurity, and most importantly, to behave as good relatives with one another. In becoming relatives, it was expected that any violence or ill feeling in the family would be resolved within the family. It would become an internal matter. It would not spill over into larger Métis-Dakota relations. By recreating individual enemies as kin, the Sissitu and the Métis transformed their diplomatic people-to-people relationship as well, creating a kinship bond between the Sissitu people and the Métis at Whitehorse Plain. The social requirement for these new relationships were demanding for both sides. The Sissitu relatives of the dead warriors were giving up any responsibility of revenge, or any possibility of revenge, against the Métis who killed their loved ones, while the Métis adoptees were accepting their new responsibilities with the Sissitu families who had been deprived of fathers, sons, brothers, uncles, and cousins. They would be expected to support these families as good relatives and embody new relations in the name of peace between their people. And in some ways, this was a sacrifice, or increased obligation on particular individuals to ensure peace for their community. By becoming kin, the Sissitu and the Métis families would be responsible then for one another's welfare and ensure a lasting peace between their broader families, potentially acting as mediators in future conflict. Unfortunately, there's no surviving correspondence after these offers were made, at least not any that I'm aware of, and we cannot be certain if Métis accepted these positions or not. But perhaps that's not entirely important. Only that the Dakota considered the Métis to be capable of becoming relatives. Maybe that, is the basic lesson here. But Alexander Ross does note that the following summer, the Métis returned to the prairies and hunted alongside the Dakota, quote, as if nothing unpleasant had happened. And later that summer, a party of Sissitu visited Red River to trade at the company's forts, and, quote, after a short stay, returned again to their country in safety. Like so many other treaties between Indigenous peoples in the Northwest, the final outcome was not written down. But we can presume again that the Métis and the Dakota smoked the pipe of peace, keeping it warm and living as relations in what the Dakota describe as peace and friendship, which had so long knit our hearts together heretofore and still continues to do so hereafter. By recreating strangers as kin, it allowed Métis to navigate complex relationships with other Indigenous peoples. And because we're at a conference that focuses both on Métis treaties and Métis reconciliation, I think this offers us three broad lessons. First of all, that reconciliation is not a simple task. And I think we often, in this era of reconciliation, particularly the federal government, sees this as a less onerous task than I think it actually is. In this case, there was no kind of ongoing injustice. That more or less there was an injustice that was quite recent, but it was easy enough to get over. If reconciliation of the kind we're talking about is, as both Corntassel and Alfred have argued, is really more about restitution, is about returning that which has been taken, whether that's land or jurisdiction or the authority to govern oneself, independent of Canada. And so I think this really points to that when both Métis and Dakota were considering reconciliation, both sides were really willing to make sacrifices, in some ways make their lives a bit more difficult in order for, at least individually difficult, for the collective benefit of their people. I'm not sure the federal government is thinking in those terms quite yet. Second, it's important to note that a longstanding legal and political tradition that was shared across many peoples, even enemies, existed on the prairies long before Canada showed up. And when we talk about treaties, particularly when Darren's going to discuss a kind of shared research interest of the Manitoba Treaty, Canada is really integrating itself into a pre-existing diplomatic space. Canada is not the one doing the integrating, it's being integrated. And it's important to note that Canada arrived into, this is my third kind of major point, Canada arrived into this context as a stranger, at least to the Métis. And so while the Métis had a long-standing relationship with the company, which I think Brenda McDougall's work highlights quite effectively, they did not see Canada as part of the same entity. And in fact, in the Declaration of the People of Rupert's Land in the Northwest, the Métis at Red River particularly refer to Canada as a stranger. And I think that this is no mistake. They're using rhetoric for a very particular circumstance to highlight a very particular type of relationship. And finally, I think Métis were attempting to achieve, much like Treaty First Nations, a kind of kin relationship that's described in the numbered treaties. That is what Michael Ash refers to as siblings of kind of the same age. Brothers of the same age, neither younger or older brothers, just brothers. This type of kin relationship also permeated the numbered treaties, which is, I think, in many ways what Métis are thinking at this time. An attempt to kind of create to use a gendered term, brotherhood between peoples, similar to Métis Dakota relationships in the 1840s. So thank you very much.
So our next speaker, I'm really pleased to introduce you to Professor Brenda Gunn. She's an associate professor at the Faculty of Law, University of Winnipeg in Manitoba. She is a member of two bar associations, the Law Society of Upper Canada and the Manitoba Bar Association. Her research focuses on gaining greater coherence. Oh, I'm sorry. All right, so at second reading, it should be better. At second reading, it should be better then. Okay, so I'm very happy to introduce you to Professor Brenda Gunn. She's an associate professor at the Faculty of Law, University of Winnipeg in Manitoba. She is a member of two bar associations, the Law Society of Upper Canada and the Manitoba Bar Association. Her research focuses on gaining greater coherence between international and domestic law in relation to Indigenous peoples' rights. So today, Professor Gunn will talk about the UN Declaration on Indigenous Peoples. Please welcome Dr. Gunn.
Thank you. I just want to say that I'm really excited to be here, but incredibly nervous. And I've been trying to center myself for a while, and it's not happening. So hopefully I will just get into the flow and things will be all good, but I want to start by acknowledging the traditional territory of the Algonquins. I'm really excited to be here. I'm really grateful that the organizers have brought us together. And also for my co-panelists. It's been really great, and I think part of my unsettledness is that there's been so much to take in today, and I feel like I've learned so much. So I am still working at digesting all that I've learned, and I've been seeing little connections and having little ideas, and I think it's throwing me off of what I wanted to say as I decided last night, and now I'm sort of have all these new thoughts. So I don't have a prepared paper. What I have are some thoughts on some work that I've been doing probably for 2 or 3 years now, looking at sort of how international law relates to treaties signed with Indigenous peoples in Canada. But it hasn't really gotten anywhere. It's just something that I've been germinating on for quite a long period of time. So I'm hoping to keep doing some of this work in relation to the Métis Treaties project, and I'm happy to share some of my preliminary thoughts with you here today. I thought an important starting point might to actually be looking at the history of Indigenous peoples and international law. And on the slide, you'll see that I've covered about 400 years of international law in about 3 bullet points. So this is very condensed, one might say. And I'm really, just to highlight the points, I'm drawing from some of the work that James Anaya and Rob Williams Jr. have done, summarizing how international law actually shifted in considering Indigenous peoples. And I think that's a really important point. I think we often talk about how Indigenous law didn't recognize Indigenous peoples, and we sort of start perhaps at midpoint in international law. But if we look back, That's the statement that Indigenous peoples were only objects, not subjects, is not necessarily true. But that became true as international law was changed in order to accommodate and justify the actions of certain colonial states. So there was a time when international scholars and potentially international law did acknowledge that as the essential humanity of Indigenous peoples, and thus were able to have certain subjective standing in international law. But as we see a shift towards a shift from the sort of natural law and looking at the humanity towards looking at nations and then nation states, we have a process by which international law becomes a tool of colonialism. And it is through this process now that international law is a legitimizing force for colonialism. And so I'm very conscious of this point when I try to argue that we can now use international law potentially to reconcile and address some of the colonial violence that continues today. So once we have international law being limited to a legal system that's governing the relations of states, being made by states for states, we see that Indigenous peoples are no longer able to be recognized as subjects of international law, and they become mere objects of international law. I think it's important to note that although this sort of became the dominant narrative in international law, there were dissenting voices at the time, and it wasn't sort of all states that were on board with this. But it is one of the difficulties we faced. And so as Indigenous peoples were no longer recognized as subjects of international law, it also meant that any of those contractual relationships or treaties that were entered into would no longer be viewed as international treaties. And so there's a 1928 case, an international arbitration case, the island of Las Palmas, where the arbiters did decide that the contracts or treaties between states and native chiefs are not, in the international law sense, treaties or conventions capable of creating rights and obligations. And so part of the work that I've been trying to think about is that statement still accurate today? Was it accurate at the time when some of the treaties were signed here in Canada, and is it accurate today? So perhaps we need to ask ourselves, what is a treaty? This is a question we ask ourselves quite regularly in the Métis Treaty Shirt Project. One starting point that people will often use is the Vienna Convention on the Law of Treaties. This is a convention that was negotiated in part to write down the rules of customary international law governing treaties. And it takes a very specific approach. It talks about treaties being written agreements concluded between states. So, and then Article 3 very specifically states that the Vienna Convention on the Law of Treaties is not going to apply to agreements or treaties concluded between states and other subjects of international law. So, I mean, at this point, I could sort of end my research and say, job done, and move on. But I guess I either didn't like that answer or I think that it might be perhaps more nuanced. And so where I've continued to look and where I want to continue to look are all the rules of customary international law that continue to exist. So the Vienna Convention cannot displace existing rules of customary international law. It merely codified a certain set of them. And so there was some dissent during this process of negotiating the Vienna Convention, and Ian Brownlee, a very noted publicist in international law, and he actually wanted the definition to be a little bit broader and include the idea of covering treaties between two or more subjects of international law. And so one of the challenges that I'm finding in my research is that if you move beyond the Vienna Convention definition, which I think is probably clear for my purposes, I want to, we get to a situation where there's really no definition. And I think I have come to a couple of explanations. I'm not sure how accurate or correct they are, but I think one is that international law is particularly vague on this process. I'm not sure that they want to define a treaty, and it's always been quite broad. And the sources say it doesn't matter what you call it, it can be a treaty. So what you name an instrument is not determinative of its status. And so I think that's helpful. So we don't really know what a treaty is, and we leave it open-ended so that we can look at agreements on its face. And so since I couldn't really find a definition, I started looking at, well, perhaps what are the different types of treaties that we see regulated? And here is really just where my thoughts are beginning. I think it's really interesting when you start to look at the different types of treaties generally recognized in international law and how they're categorized. Because if we use certain treaties, we will see that Canada's perspective, of course, would be that they're land cession treaties, right? And this is why Canada states it engaged in a lot of these processes. However, there are all sorts of different types of treaties. Some are meant to be more permanent than others. So dispositive and constitutive treaties were meant to be more permanent. They're more public in character. And those are the treaties that we probably think of as at the core of what is a treaty when we use the term in international law. But there's also a whole range of trade and commerce treaties. The purpose of these were to promote political alliances and expand trade relations. And so these treaties were not necessarily meant to be permanent, right? They might set out for a period of time or could be renewed. And so one of the questions that arises is, are there different rules of law that then apply to different types of treaties? And if so, what would those rules be? And again, part of the reason I'm asking these questions are, if we're trying to expand what a treaty is in international law and include some of the agreements between Indigenous peoples and the states, we might necessarily then need to see how international law is going to govern those treaties. So I started and I talked a little bit about historic international law and how we got to the point of taking away Indigenous peoples' subjectivity in international law. But I think it's important to also know, so I said that's not where we started, but it's also, I think, not where we are today. And I think this is in part why my interest in this area continues. People may have heard of the Alfonso Martinez report. This is a special rapporteur of the UN who spent several years looking at the legal status of treaties, agreements, and other constructive arrangements between states and Indigenous peoples. And he made several very strong conclusions. He told us and very strongly criticized states for developing a legal system, international law, and creating new rules of law that were used just to justify certain actions. And so he is very critical and I think would challenge the legitimacy of rules of international law that were developed in order just to dispossess Indigenous peoples from their land and to try to take away sovereignty. And so he very specifically says that this process of domestication of the process of treaties is unacceptable and that these are areas in which states need to take active steps to rectify. There is, though, some interesting aspects to his work, which also includes this idea of other constructive arrangements. And so he didn't just look at treaties, he also looked at a set of agreements that he called constructive arrangements. And these agreements, he says, are any legal text or other documents that are evidence of consensual participation by all parties to a legal or quasi-legal relationship. And as an example, in his report, he uses the James Bay Northern Quebec Agreement as an example of a constructive arrangement. And he says he's using that example as sort of indicative of general modern land claim settlements in Canada. And he suggests that constructive arrangements might be subject or governed by municipal law or domestic Canadian law. And so there's not a lot of support in his research for how he comes to that conclusion and how he comes to sort of talk about the difference between treaties, which he seems to view as the historical agreements, and how present-day agreements would be subject to national law. So that's an ongoing concern that I want to think about. But the other reason why I continue to look at these issues and clearly just struggle, I think you can see I'm asking more questions than answering, and my apologies for that, is the UN Declaration on the Rights of Indigenous Peoples has one particular operative paragraph that is talking about treaties. And so the UN Declaration does talk about treaties. And after a lot of very difficult negotiations, and I'm sure Paul Chartrand can talk to you about sort of the difficulties of negotiations that happened over the 30 years that it took to finalize the instrument, there wasn't a straight-out recognition that these treaties are international treaties, but the terminology that gets used is that they may have an international character and may be of international responsibility. And so I think the idea is that even if we don't sort of fully acknowledge that these treaties would be full international treaties, that at least they're not purely domestic agreements. And so I think this was sort of the compromise that was being able to be made. And I would say it's an indication of a shift in international law, away from that idea that international law isn't going to have any interest that any sort of these agreements are just subject to Canadian law. And so finally, another hurdle that I seem to have in this work, and it's clearly more hurdles, and I think I'm stumbling more than I'm succeeding, but we do have a couple of Canadian decisions where the courts have clearly said these aren't international law. So I guess I'm going to just kind of end, and maybe I should have started with this, I'm not sure, but I have no idea how long I've been babbling on for, but I hope...
5 minutes.
Oh, 5 minutes. Lots of time. So why am I doing this if it seems to have no relevance and doesn't say anything that I needed or wanted to say? One idea that I've been thinking about is, can international law, particularly when we use the Alfonso Martinez report and the UN Declaration, can international law and some of the rules that govern interpretation and upholding the obligations in these agreements, can it help us resolve some of the current debates that we have regarding treaties? And in this way, can international law provide the bridge? So when Indigenous peoples engaged in treaty-making processes with the Canadian state or with Britain or with other Indigenous nations, both parties would have brought their legal systems with them when engaging in this. And so how do you sort of have this process today of reconciliation and acknowledging these potential differences? And so I see in part international law being a tool we might be able to use to try to bridge or engage in some sort of trans-systemic legal analysis of bringing together these different legal systems. Also, there's been a lot of push over the years to have international recognition of these treaties. So I've been thinking about, well, why do we engage in this process? Why have Indigenous peoples been sort of pushing for this international recognition for so long? And I think one is the idea that it would reiterate a nation-to-nation relationship. The second main point, I think, is the hope that there may be international oversight. And three, that it would sort of move the law governing interpretation of treaties in Canada from one being of just purely Canadian domestic law to having international law, including international human rights law, help and govern the current disputes that we have today. So that's sort of why I'm engaging in this project, and I'm hoping that in a couple years I will have a lot more answers than the questions I posed today. But thank you very much for your time today.
Okay.
He's up there. You might need him. We're just going to try to do some. I have no idea where he put it in before he did it fine. I think we might need some. We have another PowerPoint if you could.
Just stick
it right in.
take that one out. Yeah, take it out. Now put that other one in. Yeah, closer. Is that it there? Is that it? Okay.
I'm just doing Mac, sorry. Oh, wow.
So thank you, Dr. Gunn, for this presentation. The Metis Treaties project is starting in some way. So all these questions are normal. They're complex questions, but they go straight to the heart of the Metis Treaties project that the team will be working on for the next couple of years. And hopefully some of the questions you raised will be part of the breakout groups tomorrow in terms of discussion. So now I'm happy to introduce Professor Darren O'Toole, who is a law professor in the French Common Law program at the University of Ottawa. He teaches Aboriginal law, Indigenous legal theory, and philosophy of law. He is a descendant of the Bois Brûlés of the White Horse Plains in Manitoba, who foisted upon the nascent Dominion of Canada the first French common law jurisdiction in the British Empire in 1870. Professor O'Toole's published research has focused on the land claims of his Métis ancestors that led to the Manitoba Métis Federation decision. His current research explores the Anishinaabe legal order. So today, Dr. O'Toole will talk about, more specifically, the Manitoba Treaty, as he names it. Please welcome Dr. O'Toole.
I didn't actually name it that. Someone gave me this title. It's erroneous, as you'll see. Yeah, just as our Métis treaty project, I wanted to dive right into it. I sort of regret doing this because I realize it's, on the one hand, very legal, so there's a bit of legal jargon in there, and on the other hand, very historical, and there's a lot of minute historical details that if you're not familiar with the Red River Resistance, I'm hoping it won't be too hard to follow. So in the recent Manitoba Métis Federation versus Canada and Manitoba case, the majority of the Supreme Court of Canada found in favor of the plaintiff, the Manitoba Métis Federation, and granted declaratory relief. The MMF case notably involved the Crown's implementation in the period from 1870 to 1880 of the 1.4 million acres of land that were granted to the children of the Métis and half-breeds, heads of family, families under the terms of the Section 31 of the Manitoba Act 1870. That's the mind-numbing prose of Section 31. And so just some comments on it. And whereas it is expedient towards the extinguishment of the Indian title to the lands in the provinces, mentions Indian title, but it's the what you might call the indigenous title of the Metis. To appropriate a portion of such ungranted lands to the extent of 1,400,000 acres thereof for the benefit of the families of the half-breed residents, and that refers to what Paul mentioned yesterday about the land being for the families and not just the children. It is hereby enacted that, and what I wanted to get at here is because in the court's decision it said that the Crown did not owe any fiduciary obligations to the Métis, and what triggers fiduciary obligations, among other things, is discretionary power. And I just underlined all the discretionary powers that were in Section 31. So under regulations to be from time to time made by the Governor General and Council, the Lieutenant Governor shall select such lots or tracts in such parts of the province as he may deem expedient, to the extent aforesaid, the 1.4 million acres, and divide the same among the children of the half-breed heads of families residing in the province at the time of the said transfer to Canada, and the same shall be granted to the said children respectively in such mode and on such conditions as to settlement and otherwise as the Governor General and Council may from time to time determine. That last sentence, on such conditions and as to settlement and otherwise, is what Paul Chartrand has called the Métis settlement scheme. And he's argued that it imposed obligations on the Crown to settle land in a particular way. Where was I? Oh, yeah. So it was one of the conditions, this was one of the conditions of the entry of what I would argue is the district of Assiniboia into Confederation as the province of Manitoba. The district of Assiniboia was slightly smaller than it was about 80 square kilometers around Fort Garry of the Forks in Winnipeg, and it was slightly smaller than what's called the postage stamp province of Manitoba. So it was in this area that the Métis, the indigenous title of the Métis would have been extinguished and not outside of that area. So what decided the issue for the Supreme Court of Canada was that, quote, the honour of the Crown is engaged by constitutional obligations to Aboriginal groups. Section 31 of the Manitoba Act 1870 is just such a constitutional obligation, end quote. However, while the 1.4 million acre land grant was ostensibly consideration for the extension of the Indian title of the Métis, the court decided that the honour of the Crown was not engaged to any collective Aboriginal interest they had in the land, but because Section 31 contained a promise, quote, a promise made to the Métis people collectively in recognition of their distinct community, end quote. The word consideration, it's a contractual term, means quid pro quo, something for something, you can't get something for nothing. Quick legal explanation of a simple word, but in this regard, Chief Justice McLaughlin for the majority upheld, quote, the trial judge finding a fact that the Métis had no communal Aboriginal interest in the land, end quote. However, what I'm concerned with here is not so much the question of the indigenous title of the Métis, although that's a question of concern, but to McLaughlin CJ's finding that Section 31 of the Manitoba Act 1870, quote, is not a treaty, end quote. So I guess I could just end things right there. And once the Supreme Court of Canada said it's not a treaty, what more can you do? And that's what I'm going to try to argue here. The court's finding that Section 31 is not a treaty is based on the fact that the trial judge, quote, and this is McLaughlin interpreting the trial judge's decision, quote, described Section 31 as a constitutional provision crafted for the purpose of resolving Aboriginal concerns and permitting the creation of the province of Manitoba, end quote. It is true that the reason that Judge McInnes the lower court judge, refused to see the Manitoba Act as a treaty, in his view, was quote, an act of parliament recognized as a constitutional document, end quote. But contrary to what McLaughlin CJ claims, the reason Judge McInnes addressed this issue in the first place is because Counsel for the plaintiff put forward the argument that the entire Manitoba Act, not just Section 31, is a treaty between the Métis and the federal government. McInnes J's characterization of the Manitoba Act as a unilateral act of Parliament throws into doubt McLaughlin's claim that he viewed Section 31 as resolving Aboriginal concerns at all, since he concluded that the Manitoba Act was, quote, neither a treaty nor an agreement, end quote, and added that, quote, it certainly was not a treaty or an agreement with Aboriginals, end quote. In his view, the terms of the Act were applied to all citizens of the province, not just the Métis, and so he wasn't, contrary to what McLaughlin said, he did not say it was for the purpose of resolving Aboriginal concerns. Getting to the point of this conference, in terms of reconciliation, when McInnes J first considered Section 31 and stated that it, quote, it is essential to remember that the Act must be looked at from the perspective of Parliament, end quote, he immediately added, quote, not from the perspective of the Métis. Yet the Supreme Court of Canada recalled, and this is simply a rule of interpretation, as was mentioned before, an act of Parliament, you look for the collective will of Parliament in order to determine the meaning of a statute, and not what, I don't know, any particular individual or group of people might have thought that it should mean. Yet the Supreme Court of Canada recalled in MMF that the, quote, ultimate purpose of the Honour of the Crown is the reconciliation of pre-existing Aboriginal societies with the assertion of Crown's sovereignty, end quote. By definition, reconciliation cannot be imposed unilaterally. As the court recalled in Delgamuukw, quote, a court must take into account the perspective of the Aboriginal people claiming the right, while at the same time taking into account the perspective of the common law, such that true reconciliation will equally place weight on each. Equal weight, but not on equal terms. The perspective of the Aboriginal people, not their laws, and the common law. The reconciliation of pre-existing Aboriginal societies, not their sovereignty, with the Crown's sovereignty. Because it's not sovereignty for sovereignty. It's not law for law. It's the factual occupation of the land that is balanced with the legal claims of the Crown. The trial judge's failure to take into account the Métis perspective of their rights under Section 31 arguably led to a truncated conclusion as to their substantive content. On appeal, Chief Justice Scott of the Court of Appeal of Manitoba noted that, quote, well, as the trial judge noted in paragraph 643 of his decision, the Act is not generally an instrument dealing with the Métis. Section 31 is clearly Métis specific, end quote. Furthermore, he was of the opinion that insofar as Section 31 is concerned, the federal government certainly was dealing with an Aboriginal people. But Scott CJ nevertheless opined that Section 31 is, quote, not a traditional historic land claim, end quote. Of course, when McLaughlin CJ found that Section 31 is not a treaty, it all depends on what exactly she meant by a treaty. And this is some of the discussion as Brenda's brought up, where we have trouble determining what a treaty is in international law. And so simply saying it is or is not a treaty, you have to specify what is meant by that term. And when she discussed the engagement of the Honour of the Crown, she was forced to resort to the, quote, analogy that may be drawn between such a constitutional obligation and a treaty promise, end quote. Further on, she commented on the, quote, treaty-like history and character, end quote, of Section 31, notably because it, quote, sets out solemn promises, promises which are no less fundamental than treaty promises, end quote. In their minority decision, Rothstein and Moldaver, judges, chided the majority for holding that it was solely because of Section 31 is a constitutional provision that it triggered the Honour of the Crown. Rothstein, who wrote the dissenting decision, pointed out somewhat wryly that the, quote, majority nonetheless proceeds to consider how Section 31 of the Manitoba Act is similar to a treaty. It thus appears that Section 31 engages the Honour of the Crown not just because of its constitutional nature, but also because of its treaty-like character. As the sophist Gorgias put it in his infamous mockery of Parmenides' On Being, It is wholly absurd that the things should both exist and not exist at one and the same time. If the promises in Section 31 are analogous to treaty promises, if it has a treaty-like history and character, why not simply call it a treaty? The answer to the treaty-like character of Section 31 may lie in the language of subsection 35.3, which stipulates that, quote, for greater certainty in subsection 1, treaty rights includes rights that now exist by way of land claim agreements or may be so acquired. This is mentioned in Paul's conference last night. It was Métis legal scholar Paul Chartrand who first proposed that Section 31 alone, and not the entire Act, quote, may be construed to be a treaty provision within the meaning of the Constitution Act 1982. Chartrand suggested more specifically that Section 31 can be construed as a land claim agreement that, quote, was reached and was entrenched in a Confederation Pact, and the rights embodied in it are affirmed by Section 35 of the Constitution Act 1982 as one of the treaties that formalized relations between the Crown and the inhabitants of the Crown when Canada assumed jurisdiction, end quote. In terms of Section 31, Chartrand admitted that it was only, quote, tentatively that it appears that the background of the negotiations support the view that Section 31 embodies a treaty in the sense of a land claim agreement, as described in Section 35.3 of the Constitution Act 1982. So what I'm proposing to do here is basically to build on Paul Chartrand's work by filling in the factual background of the negotiations. I won't be able to do all of it here, that led to the inclusion of Section 31 in the Manitoba Act. Another point is that when Paul Chartrand completed his book in 1991, was it? 1990? I can't remember. When it was first published, but when he had finished writing it, the Supreme Court of Canada had not yet decided the Seaweed case. And so he didn't have the benefit of being able to apply those criteria to his, to determine whether or not Section 31 could be considered a treaty. So in Seaway it was an interesting case, but it wasn't because it wasn't just most cases on treaties are simply a matter of interpreting the treaty. What was called into question in Seaway, much the same as in R versus Taylor and Williams, which was a case in BC that didn't go up to the Supreme Court, but what was in question was whether the document under scrutiny constituted a treaty or not. And so in Seaway, Georges Seaway, by the way, is who pleaded this case as a professor at the University of Ottawa. But so they came up with 5 criteria in the Seaway decision. I think I put them up here. Why is it not forwarding? So these are the 5 criteria in Seaway. Whether the right has been continuously exercised in the past and at present. 2, the reasons the Crown made a commitment. 3, the situation prevailing at the time of the document was signed. 4, the evidence of relations of mutual respect and esteem at the time the document was signed. And 5, the subsequent conduct of the parties. One of the difficulties of applying Seaway criteria to Section 31 is that it involves a treaty within the meaning of Section 88 of the Indian Act, as opposed to Section 35 of the Constitution Act. In this regard, Chartrand argued that the breadth of the term treaty should be construed more liberally than Indian treaty. So arguably, Section 35 should actually be larger or more, have a more liberal interpretation than Section 88 of the Indian Act. So Peter Hogg, a constitutionalist, took from Seaway and Simon the criterion, sort of rephrased them somewhat. So one, that there's the parties to the treaty must be the Crown on the one side and an Aboriginal nation on the other side. Agency, the signatories to the treaty must have the authority to bind their principles, namely the Crown and the Aboriginal nation. Intention to create legal obligations, the parties must intend to create legally binding obligations. Consideration, the obligations must be assumed by both sides so that the agreement is a bargain. Formality, there must be a certain measure of solemnity. So obviously I won't have the time to go through all 5 of those points, but I'm going to, for the time being, insist on the 4th point. But pretty much all of these points Professor Tom Flanagan was the expert witness for the Crown in Manitoba Métis Federation, and when you read the lower court decision, you get the impression that he basically adopted Flanagan's perspective, and so he basically uses his expert testimony to undermine almost all 5 of these points. For example, some of you might know that it was there were 3 delegates that were sent to negotiate the Manitoba Act in its entirety. It was Richot, Scott, and Black. And Richot was the one who insisted on Section 31, or what became the land claim agreement, what became Section 31. Flanagan says, well, he's only 1 delegate out of 3, therefore he's not really, and he had no mandate to represent the Métis either. He was supposed to represent the entire province. So you can see how the question of agency is undermined by arguments like that. So in terms of consideration, bargain, and mutual obligations, what McInnes J found in his decision was that sorry, I have to find my... when the plaintiffs argued at trial that the Manitoba Act is a treaty, so the entire Manitoba Act, not just Section 31, they asserted, quote, that there was an agreement reached between the delegates and Cartier and MacDonald as evidenced by Richot's diary record and MacDonald's handwritten note of May 2nd, 1870. So the argument was basically that, and this date is important, May 2nd, 1870, that agreement had been reached on that date. Interestingly, despite the fact they were arguing that the entire Manitoba Act was a treaty, both of these pieces of evidence refer exclusively to Section 31. To refute this argument, McInnes J not only focused his own analysis on the negotiations that led to the inclusion of Section 31, but relied heavily on the lack of, quote, consensus as to terms, certainty of terms, and finality. So these are basically contractual law terms that are what you looked for to determine whether or not a contract has been reached or not, concluded. And the main thing in emphasized what there was no agreement on the amount of land, so the 1.4 million acres, that they never came to an agreement, therefore there was no agreement reached on the 2nd of May, 1870. So there was 2 reasons, and the other reason he mentioned also too that the lands were not placed under provincial jurisdiction, but were placed under federal jurisdiction. I won't address that particular issue, it gets too complicated. So it was the delegates went to left Red River and came to Ottawa, and it was on the 26th of April that the delegates of the provisional government and the representatives of the Crown began discussing land matters. At this point, discussion seemed to evolve what eventually became the various subsections of Section 32. I won't go into that, but it's land claims that were made outside of... Richot added that, quote, after the exposition of these conditions that we accept, a long debate arises on the rights of the Métis. But it doesn't really specify what those rights are. The point is important in that Flanagan and McInnes have asserted that the discussion of the Indian title of the Métis only came about as a result of the minister's insistence on jurisdiction over Crown lands. However, a letter dated 18 November 1869 from John Young Bown, who was in the Red River settlement and a member of Parliament, that he wrote to Johnny MacDonald, made the latter well aware that the Métis were claiming Indian title long before Richot raised the issue with him some 5 months later. Also, it would appear that MacDonald had taken note of these demands, since when he wrote to Donald Smith on the 3rd of January 1870, he bothered to mention that, quote, Indian claims, including the claims of the half-breeds who live with and as Indians, will be equitably settled, end quote. And what MacDonald is referring to there is probably an act to encourage the gradual civilization of the Indian tribes in this province and to amend the laws respecting Indians in 1857, where it says exactly that half-breeds or mixed bloods that live with Indians and as Indians are basically recognized as having Indian status.
There's 2 minutes left.
What, 2 minutes?
2 minutes.
Oh my God. I'll just speed ahead here. Basically, anyway, it comes down to what Judge McInnes claims is that that on the 2nd of May, that the ministers were still proposing 1.5 million acres. Or no, sorry, Richard was still insisting on 1.5 million acres, and that the ministers were only offering 1.2 million acres. Therefore, there was no agreement on the amount of land. So at this point, however, the principle of the land concession itself, the recognition of the Métis share of Indian title, the mode of distribution, and the jurisdiction of the local legislature had all been agreed to. So there was an agreement on all these points, so that the actual principle of the land concession and recognition of Indian title had all been agreed to at this point. It was merely a difference of 300,000 acres that Judge McInnes relied upon to deny that there was an agreement reached. But even on that issue, what happened was that this was going back that even when I talked about the district of Assiniboia being slightly smaller than the postage stamp province of Manitoba, this excluded Portage-la-Prairie, and this was a long-standing claim of people in Portage-la-Prairie to be included in the district of Assiniboia. So some of the members of parliament insisted upon the boundaries of Manitoba being made slightly larger to include Portage-la-Prairie. It's interesting that when they did that, MacDonald and Cartier came to see Richard to ask him if he minded, if this was okay with the delegates, basically. So they were still negotiating at this point. They didn't just unilaterally increase the size of Manitoba. And what basically came out of that, what Richard managed to get, well, you're offering me 1.2 million acres, but you're making the province larger, so I want more acreage. So they actually did come to an agreement on the 1.4 million acres after the 2nd of May. But just, I know this is rather detailed in that, but just to show the devil's in the details, basically, and how those details are being played with to deny, which results in the Section 31 not being recognized as a land claim agreement. And on the 4th of May, Johnny MacDonald even said before Parliament, the Section 31, quote, referred to the land for the half-breeds and go toward extinguishing the Indian title. So he recognized in front of Parliament that this was the purpose of the section. If those half-breeds were not pure-blood Indians, they were their descendants. Those half-breeds had a strong claim to the lands in consequence of their extraction, as well as being settlers. The government therefore proposed, for the purpose of settling those claims, this reserve of 1,400,000 acres. So he said it right in front of Parliament that this is the agreement that they'd come to. So I'll conclude there just with one last comment from a legal perspective. If I can find the quote. Anyway, what I want to argue is that because this was never pleaded by the two parties, and it's fundamental in an adversarial legal system, and the judges have said that many times, that both parties have to present the evidence and argue the points in order for the judges to decide the issue. We have a situation here where on several of these points, they were never argued by the Council for the Manitoba Métis Federation. They never presented any evidence because they didn't argue them, and yet the judges decided it. And classically in law, when that happens, it's considered to be obiter dictum. And therefore, it's not binding on any of the lower courts, and theoretically, you could retry the issue. And it's not a moot point because the Manitoba Métis Federation is still attempting to negotiate the declaratory relief with the Crown, even as we speak. Merci beaucoup.
So we can open the floor for questions, discussions.
Hello. Hello. Okay.
Please.
Thank you. Congratulations to all the speakers. I'd like to offer just a very few comments on the subject of treaties, and these comments overlap with the last two presentations. One is that we should look carefully at the agreements that are entered into in Canada between the state, the Crown, and Indigenous people, and ask whether they have a juridical character that goes beyond what they would normally be characterized as under English law, because of the special constitutional relationship between the parties. So we can begin by looking at domestic examples and reflect on the question. For example, I'll take an example from Manitoba, the Northern Flood Agreements. Are they treaties within the meaning of the treaties as developed in the jurisprudence that you have described, and therefore protected by Section 35? And your team might examine whether there are arrangements like that apply to Métis people. My other point would be that international standards pertaining to treaties, of course, can be used for the interpretation of statutes, and so they can be very useful for the interpretation of the text of the modern treaties. And so you should keep that in mind as a point, I think, in your research. The next point I would make is this, kind of starting from the other side, looking at, say, contractual agreements between First Nations or Métis people and the government on the other hand. Let us start with the proposition that there is something that would normally fall within the category of a contract at common law. And then perhaps the next question would be, all right, in addition to accepting that agreement as a contract, a legally binding agreement, might that agreement also be imbued with additional interpretive principles that are born from that special fiduciary constitutional relationship between the parties? My final observation is one that ends up with a question or a suggestion to Professor Gunn. And I have noticed that there are organizations, the First Federation of Saskatchewan Indian Nations, for example, that emphatically asserts the international and what they call stature of historic Indian treaties, the number of treaties. And I'm a bit puzzled if they meant status as opposed to stature, but it might be useful at some point to explain the disadvantages to First Nations or Métis people of characterizing their historic treaties as in their true character as international treaties. So I think that's one of the difficulties, as many of you will know, in dealing with these questions which engage constitutional and legal dimensions, is that there's some sort of encrusted mythology that grows along with the emerging doctrine, and so sometimes people don't do themselves much of a favor in arguing certain arguments. So I don't know if you have time now, Brenda, to offer a comment on that. That is the differences between international treaties, on the other hand, and the status in domestic law of international treaties, and why that might not be such a great idea, or that may be something for another day. I don't know, but I just suggest that. Thank you.
Paul, thank you very much for that comment. I raised that comment at the Indigenous Caucus in the preparatory meeting before the 2012 treaty seminar. And I got into a lot of trouble for suggesting that there may be rules of international law that we might not want to apply to our treaties. And it was not well received by the caucus at the time. And so it is work that I do with caution of do we fully understand what we're asking for if we're asking for some sort of recognition of these agreements as international. And one example might be there are very clear rules in international law to terminate treaties. They are, even if they're meant to exist for, a long period of time, they can be terminated. And that may or may not accord with actually our understanding of various agreements. So that's, I think, one very small example that I've used at that meeting and in some of our own reflections. But I do really appreciate those comments. In that it's also far more specific than sort of my general concern, can a tool of the oppressor be used actually in some sort of decolonial process, right? So I think there's not just a sort of larger theoretical question, but a very practical, what are those rules that we then might be subjecting these agreements to? So that's where I actually am trying to sort through all these, because then you need to find the rules and then you need to think about how they apply, and that just seems to be taking me a very long period of time. But thank you for all those comments, and notes have been taken. Thank you.
For some of the people who don't have a law background, the decision, one of the decisions I mentioned, Simon, that it stems out of an earlier decision which was on the same treaty in Silly Boy. I can't remember the year it was in, but that was precisely what the judge used to dismiss it, a Mi'kmaq treaty as a treaty, because in his view a treaty was a treaty in international law, and I can't remember exactly why, but I think hostilities had come up again between the Mi'kmaq and the British, and so that in international law apparently that would automatically annul the treaty. And that's why in Simon they use the term sui generis. The other thing is, in a parliamentary system, it's what we call a dualist system, so that even though the executive signs a treaty with another country, it doesn't actually become part of domestic law until Parliament adopts it. I mention that because in the MMF case, and Paul sort of touched on this last night if I remember correctly, we have a situation where of all the treaties, this was standard procedure in the United States with treaties, that it wasn't enough that the representative of the executive signed a treaty with the First Nations of the United States. It had to be approved of by the Senate and Congress. It wasn't part of domestic law until that happened. So the only, and that's part of international treaties too. So the only land claim agreement we have in Canada where that process was respected is Section 31. And instead of it reinforcing its treaty-like character, it's actually used against it to be made out to be a unilateral act of Parliament. So it's just, the irony is just frustrating, I guess, or the double standard, maybe. But yeah, thank you for raising those questions, Paul.
Hi. I'd also like to ask or pursue a little bit this question about, what is a treaty and the base of the argument. And I think it's very useful to make these calculations. What is one trying to get? Let me suggest, Professor Gunn, that it's not only good, but it's also achievable to look at the application of human rights law for both not just oversight, but recourses eventually and so forth. But this may not result in the necessity to characterize expressions of will or positions as treaties. And just in terms of recourses and so forth, you're probably not going to get anything out of that, because in other words, it's probably more useful for Canada to become a party to the Inter-American Convention on Human Rights than to somehow recognize a treaty that's can be taken where, because it's not going to be the ICJ, because that's only member states of the United Nations, even if there are treaties. So what? So what I wanted to suggest is, if one's thinking about what are the chances of success of certain arguments, then in terms of treaty law, I would return to the Vienna Convention on Law Treaties, but I wouldn't think about the instrument. I'd think about the legal personality. And the legal personality then is not a question of whether there's a nation or a treaty. The question is there a state? And in terms of a state, I would suggest it might be more creative and more chance of success to start to say things like, in 1870, in the Red River, there was a clearly defined population with a defined territory with an effective government that could be held responsible, and therefore, under the Montevideo Treaty, which tells us to find states, you had a state, actually. So then you actually fit already in the Vienna Convention Law Treaties without having... That argument would be entirely consistent with decolonization. All the African countries before, or Latin America, there were lots of states that were not the European states or the others. In other words, recognition doesn't depend on recognition by some states. It can be... So I would think that's possibly a thought, because my suggestion would be that arguing that there's real treaties, almost real treaties, the chance of success of that typology is probably very small. The idea that Alfonso Martinez has any legal standing is dubious, subcommission expert, and so forth. So my suggestion would be to explore this idea more assertively that there are states that pre-existed and still exist that are not necessarily members of the United Nations.
Hey, sorry, I took that as things for me to think about, which I clearly was. Response, okay. Well, I think it is an interesting idea, and I've talked about it with groups of people, and I think you're right. There is questions of recognition, and some schools of thought do require more recognition in order, not just to meet the Montevideo requirements. But I will say at the international law arena, there is ongoing conversations about creating mechanisms and where Indigenous peoples can have, so complaint mechanisms, so that and actually at the 2012 conference, there was actually discussions about ICJ mandate and how you might expand these things. So I wouldn't sort of put it off. In any international institution can always have a mandate change, and we can always create new bodies, and that is an ongoing consideration in all of the Indigenous mechanisms. So I don't sort of close the door on the possibility that there would be an Indigenous-specific complaint mechanism, and that's in fact what many Indigenous peoples have been pushing for. So I think those are my comments for now. I do want to think more deeply about the comments that you made. Thank you.
Thank you very much. That was an excellent panel. All of the panels have been wonderful. I really am enjoying just hearing the thinking, and really, really a good job. I just really can't resist pointing out that we're struggling with identity, and if you look at your nameplates, we're all kind of messed up there about who you are and what's going on here. But in any event.
That's wonderful. We had no idea.
I want to pick up on a few comments. I teach my students in Aboriginal law that there were treaties before treaties that we know of today, and that, it was very common, and you gave an example today, Professor Gaudry, for chiefs to come to understandings about how their communities, their nations, the people would get along, and that often trading sons was part of that treaty process. And And then the students talk about what does that mean? What is that exchange and why would they have it? Well, you're not going to go war on this other nation, and now this son has a family unit, and then there's cross marriages that happen within all of that. And so when we talk about it, we talk about true traditional treaties and what those look like. I jokingly add that I don't know if I'm prepared to trade my 11-year-old with Stephen Harper, but it'll be Justin now, so we'll see how treaties go moving forward on that basis if we use traditional measures. But my work is with a lot of elders, and I come from Saskatchewan. This is treaty country. This is the work that I do is often with elders and often with treaty and around treaty teachings. And if you go into the Saskatchewan dialogue, we talk about spirit and intent of treaties. And the discussion at the Office of the Treaty Commissioner now is around the inherent right of treaty. And so what does that mean in terms of what I'm hearing from the panel? And you really have been pushing my brain around, and I'm trying to figure out where would I put my traditional teachings in terms of a discussion around this? When you go into ceremony and you go into ceremony for answers, those ceremonies are very personal. You take what you resonate with in that teaching, whatever that ceremony is. And I think treaty was a lot like that. I think that a lot of the relationships that were built around treaty were not about the instrument. They were about the ceremony. And not a ceremony that started and ended in 4 days with pipes and discussions, but the ceremony that we've started in a relationship together. And so somebody mentioned Chief Justice McLaughlin and whether it's a treaty or treaty-ish or what we're going to call that. Chief Justice McLaughlin also always talks about Aboriginal perspective and how we're going to include Aboriginal perspective, and we should include Aboriginal perspective, and you can't go forward without including Aboriginal perspective, and Aboriginal perspective is really, really important, and from now on the court is going to include Aboriginal perspective. So now we've included Aboriginal perspective because I've said it 42 times in one judgment. But there is no Aboriginal perspective that's being injected into that. So here's my question. How do we get at that spirit and intent of treaty? And I think Professor Dom Shanks gave a really good example in her Ile-la-Crosse discussion when she said, we've got people going in where there's a system of laws that exists already, and there's this understanding about how they're going to exist in that space together and whose laws are going to be relied on. Is that a treaty? Or is it treaty-ish? Or does that matter? What I'm going to suggest, and I don't know if Professor Dom Shanks would say this, but I would go so far as to say you actually look at the relationship that's being developed as opposed to the instrument that did it, or in addition to or in conjunction. So here's my question. Is there going to be an Indigenous process to look at that? Or are we going to continue to try to contort our identities and our language into mainstream Canadian and international legal dialogue rather than creating our own? That's my question.
I'm the only non-lawyer on this panel, but I'll give it a shot. I think kind of what I was saying at the end, I think things will change when Canadians are ready for them to change. I think we like to think you can continue to colonize and end colonialism. At least some Canadians like to imagine that. I'm Fananian in a sense, right? And ending the colonial relationship means eliminating both the colonizer and the colonized. So you can't just alleviate the colonial effects on the colonized peoples and then magically colonialism goes away. I don't think we're at a stage yet where Canadians are willing to give up what they have. And I think that's the ultimate discussion. That's when things will change, is that once people start to listen and I think are willing to sacrifice something in the name of justice, I think that's when things are going to change. I can't really speak to the legal element of that, but I think in the practical political circumstances, that's where we're trapped, is that when a certain group of people is willing to learn about this sort of thing in a deep and impactful way, then things are going to change. And I think we're seeing in activist circles, we're seeing a lot of that on a small scale. I don't know when that's going to transcend those communities, but I think that the kind of constant struggle is that we have to couch our arguments in language that's inoffensive to other people, in ways that fit within a worldview and kind of limit the threatening nature of kind of what we're arguing for. I don't know. I'm optimistic that this will happen, but I'm also kind of cynical, I think, with how this gets taught, you know. The John Ralston Saul argument where, you know, we're all Métis, therefore all Aboriginal, therefore colonialism's over, is, I think, a really attractive argument to a lot of people because it solves some problems, but it doesn't really kind of cut to the material realities of colonialism, which is that this country's wealth is based on resource extraction, which is based on access to indigenous lands and the rejection of treaty relationships that say something very different. Again, I'm not a lawyer, so that I don't know how that converts into law, but I think that's kind of the material circumstances of colonialism as I see them. Yeah.
Oh, that's a really big issue. I would say in Anishinaabe-Moan, the Ojibwe language, the treaties, in Treaty 3 at least, it's Mazanati Gunn Manidu, which means spirit paper. Or, it's a rough translation. But it's seen as a form of law, so it's the problem, I think, more than just treaties, is the recognition, and it's the same thing with the Indigenous perspective. The court has said that several times, that part of the Indigenous perspective is our Indigenous legal orders. John Burroughs has been promoting that a lot. He has a book, Canada's Indigenous Constitution, and I think that's basically his approach. He's sometimes when I teach it in my class, and some students are, particularly Aboriginal students, are almost like, doesn't he ever get angry? and they want to see that kind of more, I don't know, Tyge Alfred kind of thing. And I said, well, I think he's exactly what Adam was saying. It's kind of like he's built a canoe that just glides through the water and disrupts the least possible. And he's trying not to offend people, to make them so that they're in a state where they can hear what he's trying to say. But he even mentions in his book that he did a presentation on Indigenous law in BC, I think it was, and a judge from the Court of Appeal of BC came to him afterwards and said, I don't believe there's any such thing. So we've got judges that think like that. That's how do you get a judge like that to write Indigenous law into his decision? The Grassy Narrows case that came out recently, which was Treaty 3, the same thing, the Indigenous perspective and everything like that, but in the end, they basically reconfirmed St. Catharines Milling and Lumber, which is a decision from the 1880s. There was never any doubt of the underlying title of the Crown. Is a phrase that they repeat. How did they get the underlying title? We don't know. But there's no doubt of it. And again, this unequal thing of even when they express reconciliation, reconciliation is on unequal terms from the very beginning. The Crown can just declare its sovereignty, and it magically obtains underlying title just by doing so. But it's and the reason I mention it's spirit paper, what I'm getting to is that, you know, Indigenous peoples are often accused of being superstitious or, you know, believing in things that don't exist and all that kind of stuff. And I think, well, what about the Crown? What the hell is that? The Crown declares sovereignty and it obtains underlying title. That's pretty, we call in French la pensée magique. But yeah, so I think one of the starting places, what came out in the Truth and Reconciliation Commission is integrating Indigenous law into law faculties as a starting point. because hopefully some of those law students are going to become lawyers and eventually become judges and actually have the tools to be able to. And I think that's part of the problem. It's not necessarily a question of bad faith in that. There's sometimes that just some of these judges, they have no idea what Indigenous law is, and so they mention it, and there's sort of a nominal recognition, but they don't really know how to apply it or how to interpret it in that. And so I think in the end, as in Grassy Narrows, it was just completely ignored at the end. Then the Indigenous Bar Association actually was an intervener in the Supreme Court and pleaded Indigenous law in that particular case, and it was just, there's no trace of it in the final decision. So, yeah.
So we're going to go in one last question. I know you've been standing there for a while, so and then perhaps for the last word with Mr. Belcourt, of course.
Thank you very much. I really enjoyed the panel. My question is for Darren and for Adam. One of the things I was interested, Darren, that you use a lot of the deliberations between Cartier and the representatives from Assiniboia. I'm wondering how you deal with the problem, or just the reality that the language of treaties in Red River is actually quite well understood and had been discussed and debated quite extensively from about 1860. And within the community, there seems to be a very strong, seems to be a lot of disagreement about whether or not they in fact want a treaty. So this comes up in the Convention of 40, which is the legislative body that comes together that tries to pull together some sort of Bill of Rights that then eventually is sent off to Ottawa. And there's a disagreement within that body about whether or not, in fact, treaty is in fact something that they should seek to begin with. So even in the language as it's deployed at the time, there seems to be a conflict within the community about whether or not they should advance a treaty project politically. And I was wondering, both of you, how do you reconcile that with your arguments? Thank you very much.
What's that? Do you need to go? Or? Okay. Brenda has to catch a plane, so I don't know. Did you want to comment first? Okay. I had an idea in my head, and I can't remember what it was. No, it's true. In the Convention of 40, it's actually one of the few times when Flanagan claimed that there was never any collective land claims made by the Métis. And it's a touchy issue because there's a clause in one of the lists of rights, as you probably know, that it mentions negotiating treaties with the Indians, as it mentions. And when this clause is brought up for discussion by the Convention of 40, Riel stands up and says, are the Indians the only ones that have a claim to land in that? And so he's obviously making a land claim for the Métis when he says that. And James Ross, who's sort of recognized as the leader of the English half-breeds, as they termed it, he basically says to Riel, we have to decide whether we want the rights of civilized men or the rights of savages. And he makes a joke about, do we want blankets and tobacco or political rights? And it's sort of what's brought up earlier, I think, by Chris and others, about how those colonial categories and dichotomies have been, it's sort of a Frantz Fanon sort of thing too, that we've integrated those categories into our thinking. And so yeah, and it's understandable, but not to, because the mentality at the time and of the colonial governments was that if you were an Indian, you were a ward of the state. You had no political rights, basically. And the only reason that the half-breed population decided to support the Métis in the provisional government, that was to gain they'd already been fighting for this for 10 or 20 years previously, for their political rights, the right to vote, and the right to have an elected, democratically elected body, and that. Well, if that's the reason they're supporting the Métis, and having Indian title would automatically mean losing those very rights, how do you support that? So yeah, so it was a difficult issue at the time. And even when the Manitoba Act was brought back to the settlement and the provisional government now, the Convention of 40 had been dissolved, and that was a real area of concern. That was Section 31. It was specifically, I can't remember what's his name, the treasurer, the Irish fellow. he brought it up twice in the newspaper report, asking Richard. What's that?
O'Donoghue.
Yeah, O'Donoghue. That's it. Yeah, the evil Irish terrorist. But but he brought it up twice and sort of asking, and it's weird the way he said it, because he asked a question to Richard, but he sort of says that the member beside me is wondering, and so he's wanting Richard to reassure the other members that they're not going to lose their rights. And Richard's sort of stuck in this position where he does this little dance kind of thing, and he's trying to please everybody, but he ends up saying contradictory things to do so, and that was actually used as evidence in the court too, against that Richard didn't really believe that the Métis had Indian title and that, because of some of the statements he made at that time. But yeah, no, it is a difficult issue, and it's being caught up in that colonial situation, and what was I think what was brought up is the problem of and I think that's even the case with the Section 31 generally. I mean, it was Richard, a European or Euro-Canadian, that negotiated. There was no Métis amongst the delegates, and so that idea of kinship and everything like that, I think, was totally lost at the time that it was negotiated in Ottawa. So yeah, there's a lot of problems in terms of divergences in interpreting the what was exactly meant by those agreements.
Mr. Belko?
My question is related not to the treaties that exist, but the ones that don't. In Pauli, one of the issues was the question of whether or not the rights still existed, or were they extinguished, and the Crown's position was that they were. And the decision was that because the Métis were not allowed to participate in the Robinson Huron Treaty in Sault Ste. Marie in 1850, their rights were not extinguished, and therefore, since the community was still existing and in continuity and all the rest, the people there then therefore had the right to hunt and fish for food. I remember years and years ago, back in Alberta, finding out that in Treaty 8, representatives from our communities had gone up there only to be told that we're not having a treaty with you, we're having it with the full-bloods, and others will come and have treaty with you later, which never happened. Same thing happened in Treaty 9. I don't know how many other places it happened. But what are the implications of that? That there were treaties that took place and where Métis were, and there were no treaties with them. The one in Manitoba is clear. But what about the rest?
Me again? No, it's a really good question, and I think what's actually been going on here in with the Algonquin land claim is maybe an example of that, where the Crown thought it extinguished all of the title in the area. I can't remember what is it treaty. What's the number of the treaty that's in this area? Is it 11 or? I get them mixed up. But what's? Oh yeah, 11's up north. It's I can't remember which treaty, but in this in the Ottawa area, that there was actually a treaty that was supposed to extinguish Indian title in the area, but they didn't include the Algonquin in the negotiations, and so this land claim agreement that's between the Algonquin and the Ontario and the federal government sort of comes out of that. So there's a precedent there of recognizing that groups that were actually living there at the time that were not included in the treaty still have an outstanding claim. And so I think there's treaties yet to be negotiated for precisely that reason. But yeah, they came over and over again, right from Robinson Huron to everywhere else. We have no mandate to negotiate with the half-breeds.
There was also, Rob, correct me on Treaty 6, there were chiefs that attempted to bring Métis and half-breeds into the treaty 1880? 1880, 1881?
Well,
Yeah.
they did it in
Yeah. Yeah, in Cyprus, there was like a brewing conflict over shortage of buffalo, and the treaty chiefs, Little Pine and someone else. Yeah, argued that the Métis should be brought into treaty. They want all the natives of the country, I think was the expression used, which meant Métis included in the treaty when people, and then buffalo showed up and kind of diffused the conflict, but there were several points on the prairies too where treaty chiefs were advocating for inclusion of Métis bands as treaty bands. I guess it never happened, or they were incorporated piecemeal as individuals. But I think there were several attempts even on the prairies in the numbered treaties to include Métis in forms that Métis desired to be included, but yeah, it didn't happen. Lucky man, that was the other chief.
Thank you very much. Oh, you want me to? Well, they're also going to receive a great gift from the Gabriel Dumont Institute for each. And I thank you very much for your attention. I'll leave the floor to Larry.
Okay, thank you very much. A round of applause for the audience. And for our panel. We've had a good dialogue. I'm not going to hold you up much longer other than to mention we start again 9:30 tomorrow. We have one panel, and it's about the Daniels case, primarily, and about the implications of that important case. And then there's the round table, a keynotes luncheon, and then kind of a wrap-up of where do we go from here. So I'll see you tomorrow morning at 9:30. Also, I just want to remind you of Jamie Cobo's Indigenous Walk. Starts at 8 p.m. tonight. It's a really interesting thing. Meet at 2 daily, and you might see these in your kits if you want to follow up with that. So have a good night. You're free tonight, and I'll see you tomorrow morning.
Thank you very much.